President of the Republic of Kenya, Dr. William Ruto, has nominated the current Director of Public Prosecution, Noordin Haji, to be considered by Parliament for the position of the Director of National Intelligence Service. We have seen quite a number of opposition. A petition has been filed in Mombasa, in Nakuru, and in that petition, our client Aisha Jumwa, the Minister for Gender and Public Service, has been mentioned adversely. That Noordin Haji dropped out the charges for Aisha Jumwa because of pressure, because of undue influence, because of other reasons. We have firm instructions from the Minister, that is Aisha Jumwa, to come on record. We have already made an application to be enjoined in that suit, and we shall be raising very, very, very serious issues about that petition. Secondly, it is in public knowledge that the civil society has come out critically challenging the suitability of Noordin Haji. Our position that we are filing is as follows. One, that we did write letters to Noordin Haji, the Director of Public Prosecution, pursuant to Article 157, to review, because a miscarriage of justice under Article 157(11) was being occasioned. And Noordin Haji, after considering the facts that we gave, requested the courts under Article 157(8) that there is no sufficient evidence to prosecute Aisha Jumwa and the others. It is the courts that agreed with the reasons given by the DPP, and that is how Aisha Jumwa, the minister, her charges were withdrawn. That being the position, I want to bring to the attention of the court. I myself and the team behind us filed more than 21 petitions for the removal of Noordin Haji. Out of the 21 petitions, all of them were dismissed. Reason being that the power to decide to charge, the power to decide to withdraw, the power to decide to prosecute is only vested in the office of the Director of Public Prosecution. Therefore, none of the people raising storm now ever challenged Noordin Haji when he was in office. What is the reason that they are now trying to challenge Noordin Haji? Number two, we filed several petitions in court. The Labour Court, filed in the Constitutional Court, challenging the power to charge and to withdraw. And all the courts dismissed our applications on the basis that the power to decide to charge, to decide to withdraw, is vested only in the person of Noordin Haji. So it is our considered opinion that the civil society that is raising this issue now wants to make funds. They want to raise money. It is a money minting exercise so that donors can send money. Nobody raised an issue all this time from the civil society when Noordin Haji was charging or was withdrawing. They kept quiet. So this is a financial, commercial endeavor by the civil society to look relevant, to attract foreigners to give them money, and so that they know they will not succeed. It's not the first time We've seen them when President Uhuru Kenyatta counsels. The allegations that are being put there is a complete political witch hunt. The fact that Noordin Haji served under President Uhuru Kenyatta does not disqualify him from being nominated to serve in the office of the Director of NIS. I myself, we've brushed shoulders with that Noordin Haji. I'm the first one to say that Noordin Haji is competent for the purpose of being the Director of Intelligence. He was a deputy in that office. For over 15 years, he was a deputy or director in IS. Where were these people when Noordin Haji was discharging the mandate of NIS? Where were they when they were saying Noordin Haji withdrew cases? Did they go to court to challenge? Did they file a petition before the Public Service Commission that one Noordin Haji has withdrawn the matters? Did they take a petition to Parliament? Why now? The timing is political. It is political witch hunt. And for the record purposes, withdrawal of cases yearly, anybody will go to the ODPP report to Parliament, annual report to Parliament. An average of 18,000 cases are withdrawn annually per year. So, if he withdrew 4 or 5 matters, what about the other 18,000 Kenyans who benefited from Section 87A of the Criminal Procedure Code that allows the DPP to withdraw matters? So we see an orchestrated political agenda to stop one Noordin Haji from ascending to power as the new Director of Intelligence. What do they fear? Are they fearing that the Director of Intelligence is going to get intelligence and give it to law enforcement officers and block those NGOs because their role, their money is not utilized for the sake of the country? It is the money that is taken to their pockets. So we support, and we will be supporting that petition that one Noordin Haji be appointed. We shall also be swearing affidavits, taking them to Parliament to say that one Noordin Haji is being hounded out of office. Remember, he has not resigned. He's still the Director of Public Prosecution. His name has only been mentioned, and there's a lot of political witch hunt. My good sister will deal with the powers as provided for in Article 157.
Those who may not be privy to information pertaining the role of the Director of Public Prosecution, it has been elaborated under Article 157 of our Constitution, which then gives the Director of Public Prosecution his establishment. He is a creature of the Constitution, and he can only act within the purview of the Constitution. Just as Mr. Omari has said, it is not a scenario where the Director of Public Prosecutions has been removed from his official seat, nor is it an instance where he has then recused himself, or he has decided to leave the office early. The law says that a Director of Public Prosecution ought to be in his seat for a period of 8 years. The 8th year for Mr. Noordin Haji is lapsing this year, and that is why any invite or any other job offer that he may have gotten, such as the Director of Public Prosecution the Director of Intelligence, should be welcome, because what we have seen is, contrary to the many assertions that were there during his tenure of his incompetence, all those complaints were channeled in the proper channels. We did take various petitions to the Public Service Commission, but when we went there, we found out that perhaps we may have been misguided, because he was never removed as the sitting Director of Public Prosecutions. And just as Mr. Omari has said, When all these claims were being done and it was a matter of public interest, where were the civil societies then? Why did they keep quiet up until now, when he is now being called to assume another role, is when they are bringing out their dissatisfaction. Even when they talk about the numerous matters that are being withdrawn by the Director of Public Prosecution, it is within his purview, it is within his job description to check on the cases that they are taking to court as prosecutors and see whether they are going to be able to sustain a case so that they do not end up embarrassing the court or abusing the court process or wasting the court's time. That is why we have accepted his wisdom and seen that even the matters that they withdrawn before the courts are cases that perhaps may have taken so much of judicial time, which have been having a political vendetta and agenda all through. Where were the civil societies when these matters were being withdrawn? Why are they speaking now that it is only in the headlines that Mr. Noordin Haji intends to be appointed as a director of the NIS? Therefore, we are questioning the mindset or the mind frame or the intention, the motive that the civil societies have right now in going to court to try and say that Mr. Noordin Haji is not competent. Yes, they have been quiet since he took power. Therefore, we are behind Mr. Noordin Haji, and we hope we wish him all the best in his future endeavors, even as he continues to serve our great nation.